sure how that
Oh,
happened.
well, I just got a notification on the screen that we are live on YouTube. So,
Okay.
all right. So I think we're all set. We're just going to wait on that script then.
Do you have a script, Cameron?
I do. Yep.
Go ahead, read it.
Okay. Welcome. I am Cameron Lapine, legislative aide to the Senate Executive Department's Administration Committee. Before we get started, on behalf of Senator John Reagan, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the right to know law. On behalf of Senator Reagan, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I'm confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. We provide public notice of the necessary information for accessing the meeting in the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remote-senate@leg.state.nh.us or call 603-271-6931. In the event the public is unable to access the meeting, it will be adjourned and rescheduled. Please note that all votes taken during this meeting shall be done by roll call vote. Finally, let's start the meeting by taking a roll call attendance. When each member states they're present, please also state where they are and if anyone else is in the room with you during the meeting, which is required under the right to know law. Senator Reagan.
Senator Reagan, I'm in my State House office by myself. Senator Ricciardi.
Senator Ricciardi. Oh.
Good morning, everyone. Denise Ricciardi. I'm in our home in Bedford. My husband and some construction workers are in the house.
Senator Kavanaugh.
Hello, Kevin Kavanaugh, my home in Manchester. My wife and son are in the house, but I'm alone in the room.
And Senator Prentice.
Good morning, Sue Prentice. I'm in my home in West Lebanon. My husband and trustee Doug Mazie are in the house, but I'm alone in this room. Thank you.
Okay. House Bill 606. Do we have a sponsor?
Reagan, I don't see, actually, yes. Representative McGuire, you should be able to unmute.
Yes, thank you. Good morning, Mr. Chair, members of the committee. I'm Carol McGuire, representing Merrimack District 29, which is the towns of Allenstown, Epsom, and Pittsfield. And I'm presenting to you House Bill 606, which simply removes free services from the criminal definition of the cosmetology statute. This became an issue during the pandemic when barbershops and beauty parlors were considered non-essential. And so a great many people have confessed to criminally cutting their spouse's hair or trimming their fingernails or whatever. There are no exemptions from that criminal statute right now. So if you are a group of teenage girls playing with makeup or hairstyles, you are committing a misdemeanor. If you are cutting your baby's fingernails, you are committing a misdemeanor. So this is to exempt free services from that criminal statute, and I'll be glad to answer any questions.
Questions from the committee? Seeing none, do we have any other persons giving testimony?
We do. We have another representative. Representative, you should be able to unmute yourself.
Yes, can you hear me?
Yes,
My name is Marc Allgro, and I represent Grafton's 7th District. I'm not going to reiterate what Representative McGuire said, but I have another approach, and I'd like to address some of the criticisms of the bill. I think they're very easily blunted. So, first of all, thank you, Mr. Chair and Senate EDA committee members. Opposition to this bill warned that the public's at risk from unauthorized use of dangerous chemicals or from transmissible disease. But I want to emphasize that no evidence in support of this claim was presented at all during testimony before our ED&A committee in the House, or during executive session and debate, or before the full House. Now, related to that, when I'm in a bit of a humorous mood, I like to ask, dangerous chemicals like Head and Shoulders shampoo or CVS hair coloring? I know that there are more harsh treatments than those, but the fact remains, as Representative McGuire alluded to, these simple treatments are lumped together under the current legal structure. And then finally, what I think was the worst argument against HB 606 was saying that no one is ever prosecuted for the personal acts I mentioned above, or that Chairman McGuire mentioned. It's argued that selective law enforcement renders HB 606 unnecessary. And I would suggest that selective law enforcement is a far greater threat to public safety than Ms. Clairol. It not only allows for proactive use of selective enforcement for the most odious purposes, but it undermines public respect for the law and lawmaking. So again, as crazy as it may seem, the fact is that under the current statute, it's a crime for you to help your grandmother get a little of the gray out or to file your sister's fingernails. House Bill 606 remedies this situation. And what I consider the bottom line is it's really not government's role to interfere with the highly personal acts that we just mentioned. And a vote to pass 606 is a small step in restoring this right of caring for one another. Thank you again. And if I can answer any questions, I'll be happy to.
Senator Prentice.
Thank you, Senator Reagan. So Representative, all we're doing here is saying if you do this for money, if this is your profession, you have to be licensed.
No, it's
Or
actually,
you could have a fine.
It's actually saying the other side of that coin. Thank you for the question, by the way. It's saying if you're not doing it for money, you don't have to be licensed.
Okay.
This in no way affects professional cosmetologists or anybody who's getting paid under license. It's just for freebies.
Okay. I think we're on the same page. I got it. Thank you.
Okay, who else do we have?
We have Ross Connolly. Mr. Connolly, you should be able to unmute yourself.
Hello, can you hear me?
Yes,
Thank you, Senators and Mr. Chair, for holding this hearing. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity in New Hampshire, and I'm just here to voice our support for HB 606. I'll be very brief since the previous speakers covered a lot of my points. This simply aligns our enforcement policy with our state statute. As has been pointed out, it became readily apparent during the outbreak of the COVID-19 pandemic that thousands, if not tens of thousands of Granite Staters were guilty of a Class A misdemeanor for cutting their family members' hair and whether they do their family members' nails, as well as has been pointed out. But a lot of the arguments come that this statute is not enforced. However, if a law is not enforced, then it's pretty unnecessary. And to keep it builds a lot of distrust with the public. And this simply aligns our state statute with the enforcement policy to allow people to have haircuts and give haircuts without remuneration, and builds a lot of trust with the public to eliminate this provision. So with that, I'd be happy to take any questions.
Questions from the committee? Senator Prentice.
Thank you, Senator Reagan. Was this, I guess, thank you for taking my question. So was this an oversight? I mean, people can buy, give themselves home perms. They can color their hair. They can do all the same things that can be done in a salon. The difference is licensure and paying someone for doing the service. So you're saying that as the law existed before, if you did those things, you're in violation of the law?
Thank you for the question, Senator. Yes, if you did, because of this provision that didn't have the full remuneration that this bill adds, anyone that was cutting hair or any of the examples you gave without pay, that they were guilty of a Class A misdemeanor. Obviously, that is not enforced. It would be pretty crazy to enforce that. But we just want to make sure that the statute is actually aligned with the enforcement, that if this law is not being enforced, then, which I don't think anyone is arguing that it should be enforced, that we're being very clear in how the statute reads.
Other questions? Go ahead, Senator.
No, it's OPLC, should they weigh in? I'm okay with this. I'm just shocked that, this was either left undone or the way it's been characterized. I'm happy to move on this. Do we want to hear from the cosmetology folks at all, or we can just move forward? Senator Reagan, what do you think?
No, Chairman McGuire stated that this was just an oversight in the original drafting of this law.
Yeah.
So, and this straightens out a misstatement. So.
Okay, and I'm great, solid with Representative McGuire's testimony. I'm just, I'm having a minute for every time that I, like did my nails at home. Okay.
Oh,
right.
So you're an offender. Okay.
Exactly.
Well, this will keep you out of prison.
I think somebody's about to ring my doorbell. Oh no. Okay.
Okay. Any other questions? Okay. Thank you, Mr. Connolly. Anybody else?
Senator Reagan, I don't see anyone with their hand raised.
Great. Okay. And we'll close the hearing on 606. House Bill 575.
Representative, you should be able to unmute yourself.
Yes, thank you very much. For the record, my name is Glenn Cordelli, and I represent Tufton Borough, Moulton Borough, and Sandwich in the beautiful Lakes region. Thank you, Chairman Reagan and Senators, for this hearing this morning. I sponsored HB 575 at the request of the friend of a former House member. And the bill makes several adjustments. Section 1 of the bill deals with qualifications for a cosmetologist. And the current requirement is training of a minimum of 1,500 hours or 3,000 hours as engaged in the practice of cosmetology. HB 575 modifies that to 1,500 hours at a cosmetology school and or training with a licensed cosmetologist. Looking at other professional requirements in this chapter, I believe this is a reasonable requirement. Section 2 deals with manicurists, and that requires, the bill requires 300 hours in approved school or in a salon as an apprentice. Section 3 is for estheticians, and we changed the qualification to 600 hours at a school or working 600 hours as an apprentice. Section 4 deals with apprenticeships, and it changes the current language that the board shall issue an apprentice license to any student receiving instruction within a licensed school or shop to learn barbering, cosmetology, etc. In the bill, we change that to within a licensed school and or shop. And I think that's an important distinction. And these changes are made when you look at other requirements for training in our statutes. For instance, driver education, which is pretty important, requires 30 hours of classroom training, 10 hours of practice driving, and 6 hours of observation. A home inspector requires 80 hours of education. Family mediators simply require instruction of at least 48 hours in length and 20 hours with a mediator. So I think that these are reasonable revisions to our current statutes. I know that the apprenticeship section in 313A:24 is also the subject of legislation already passed by the Senate, SB 133, and it changes the word license to certification. And I know that the House committee is dealing with 133 currently and is aware of that change. I think that we should encourage people in the workforce and provide additional opportunities. And this bill offers small steps to open more doors for people to enter these professions, but also keeps in place reasonable requirements for public protection, in my opinion. And I thank you very much for your time this morning.
Questions from the committee? Seeing none, thank you, Representative Cordelli.
Next, we have Representative McGuire. Representative, you should be able to unmute yourself.
Thank you. Thank you, Mr. Chair, members of the committee. I'm still Carol McGuire from Merrimack 29, and House Bill 575 was passed by my committee. We are currently working on Senate Bill 133, as Representative Cordelli mentioned, and most of the bills are independent, but one section is amended by both bills. So what I have done in House eDNA is to amend that section to include the and or, which will allow a person to get some training in a school and some training in a shop, which by connections in the cosmetology world say is probably the most efficient way to get fully trained. And then I have for your consideration an amendment that would say that if both bills are passed, that one section of 575 does not apply. And we chose to do it that way because the changes to that section and Senate Bill 133 are more extensive. So we simply added the and or in Senate Bill 133, and Senate Bill House Bill 575 has an amendment that would say if both bills pass, don't overwrite Senate Bill 133 with this one. So I'll be glad to answer questions.
So that amendment is already attached to the bill as we've received it from the House?
No, sir.
No, okay.
It is, Senator Carson and I worked on it, and it should be available to you. Let's see.
Pam, do you have that?
Off the top of my head, I don't. Let me do a quick search here.
Deb Kroniak definitely has it. She's the one that got it for us.
Yes, I do have that. It's 1209S.
Okay.
Yes, and I would encourage you to pass that because we're in the middle of executing Senate Bill 133, and that section was unanimously approved by the committee.
Okay, we can do that. Questions from the committee? No, we're all good. Thank you, Chairman McGuire. Do we have anyone else?
We had Representative Lekas signed up, but I don't see him in the Zoom.
Okay.
And no one has their hand raised.
Excellent. So we'll close the hearing on House Bill 575 and open the hearing on House Bill 417.
We are 2 minutes ahead of schedule.
That's okay. We won't take any action until 9:30, but we'll start the hearing now. And our sponsor is?
It is Representative Roy.
Go ahead, Terry.
Good morning, Senators. Thank you for taking time to hear about HB 417. As I'm sure you're all aware of, all of our constituents from the House and Senate throughout this pandemic have really expressed a lot of concerns about the executive wielding so much power for so long in the state. The original emergency order bills that we passed never contemplated something of the nature that this has been and lasting as long as it has been. In effect, for the last year, our constituents have been unrepresented by us. They've had one branch of government, and that's the executive branch, enforcing and making laws. Now, that's not to criticize the way it was done. This isn't about Monday morning quarterbacking. This is about saying, okay, we learned from this, and this is what we don't want to happen in the future. So this bill was carefully considered. It was well balanced. We actually extended the what was in statute from 21 days to 30 days to give the governor 30 days emergency powers. And 30 days should just about cover any emergency that we have contemplated, such as a storm or other natural disaster. Anything beyond that has to come before the legislative body for approval, and that includes executive orders, so that we can answer our constituents when they say to us, well, why is this happening, or what is the reasoning behind this? Right now, if you're like me, you learned a lot of this just by watching newscasts or reading it in the media, or my constituents emailing me saying, what is this about? I hadn't even seen the order yet. So it brings us into the position that we can actually represent our constituents instead of having to explain to them that we don't know any more than they do. I think that we tried to balance it as much as possible. In the event that the governor wouldn't be able to get us together, it automatically extends until at such time as we can get together. We tried to think of everything possible, but as this pandemic has shown us, that's impossible. So we did our best. With that, I'd be happy to take any questions.
Questions from the committee? Senator Prentice.
Thank you, Senator Reagan, and good to see you again, Representative Roy, or hear you again. So just help me to understand this, the timing. So it's 30 days. It would be extended 30 days after the declaration, unless it's renewed, and the renewal would be by a majority vote of the legislature, each chamber, correct?
That's correct.
Okay, and you just mentioned something about what if these bodies can't get together? And I'll have a follow-up to that. I'm just looking at the timing. If we can't get the legislature into session and get whatever orders or laws need to be passed, taken care of. You said there was some automatic renewal.
Yeah, I believe it's 14 days. It automatically renews for 14-day increments. So let's say for whatever reason he can't get us. in session, it'll just keep renewing until such time as we do.
Okay, follow up?
Yeah.
Go ahead.
Yep, thank you. I think I was going, all right, so 30 days and then until the legislature has taken an action, it extends by periods of 14-day increments?
Yes, that's correct.
Okay,
And if you read the bill at the bottom, I even, we thought about it and we put in there that the executive branch has to help us get there. So if there's a natural disaster and the only way to get in is, a government plow, well, he's got to help us get there. It's got to be a combined effort. And we also put in there that executive orders could not in any way affect members of the legislature so that we're unable to get out and represent our people and see what's going on.
okay, follow up?
Follow up.
Okay, so just to be clear, I did read the bill. I just wanted to understand that. I have a background in public health, public safety, emergency management, emergency medical services. So emergency orders in a time like this, a pandemic, which is completely unprecedented. I hear what you're saying. It just really concerns me. So I'm looking for clarity because my biggest worry in any action to shift away from the executive is that we can't get in a timely way and can't get the work done. And that's all I'm trying to clarify so that I know that if this action is going to go forward, that there is a clear-cut, timely mechanism for the legislature. I might be new, but I've already had an experience where we raced to pass a bill in the Senate chamber and moved it over to the House, and the House didn't take it up. And that was the first Senate bill too at the beginning of the year. So Representative Roy, I've read the bill. That's just my concern. I'm trying to be clear about. That's all.
Oh, sure. And I had the very same concern. I have a background in public safety as well. And I understand that the executive needs to be able to move quickly and swiftly in certain circumstances, which is why we said, okay, first of all, we're going to give him 30 days instead of 21 before he even has to talk to us. Then if for whatever reason we can't get off the dime and get in there, it's going to extend automatically anyway for 14 days until we can actually get in there. So I made sure that the executive has the flexibility he needs until we can get together. Now, if we get together and we don't agree with them, we don't agree with them.
Right.
But at least we have a seat at the table.
Okay.
So I hope that covers your concern.
It does. And thank you for the clarification. Just want to be clear. Thank you.
No problem. No, that's what I'm here for.
Other questions from the committee? Seeing none, who's the next witness?
We have Representative McGuire. Representative, you should be able to unmute.
Yes, thank you, Mr. Chair, members of the committee. I'm still Carol McGuire, Merrimack District 29. And House Bill 417 was amended by the ED&A committee in the House to make sure that it did not interfere with the actual emergencies. We did some studies and nearly all of our normal emergencies, weather or whatever, last 30 days or less. So we made sure that in those cases, there would be no change to the current emergency powers. However, if it starts lasting longer than that, we felt that the legislature should be getting involved. And I would like to point out that this bill does not apply until after the end of the current emergency, so that it is for future emergencies only. And it is a kind of a draft on how we should change the emergency powers, but it addresses the issues that most people had. Namely that the emergency orders were not reviewed by anyone, that the governor had absolute authority to accept money and spend it with no oversight at all. So this adds to the receipt of funds, governor and council, and that kicks in the fiscal oversight for large amounts of money, because we felt that putting the entire responsibility of emergency funds on the governor was unnecessary and excessive. So that was the other change we made. And it worked out that it ended up passing the House by an overwhelming majority.
Question from Senator Kavanaugh, unmute.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. You mentioned in your study that you had, I'm just kind of curious, do we have any, like a number of times that it extended well beyond? I know this is unprecedented. Probably something like this has maybe happened in 100 years ago, but did you look at how many times it has happened beyond the 30 or 60 days?
We couldn't find any, but we didn't do it as exhaustive as, we didn't go back 100 years, that's for sure. However, when we looked at the House journals from 1917 during the Spanish flu pandemic, the word influenza never appeared. So.
Interesting. All right, well, thank you.
Any other questions? Thank you, Chairman McGuire. Do we have any other witnesses?
We have Representative Schmidt. Representative, you should be able to unmute yourself.
I pressed the button. Can you hear me, folks?
Yes.
Thank you, Mr. Chairman. Good morning, colleagues. So I thank both my colleague, Representative Roy and Representative McGuire, for their efforts in this regard. And I don't disagree with the attempt. However, I think that this is fundamentally, well, first of all, because it doesn't address the current situation. As I say, I sent you my blurb that was in the House calendar when the bill was argued on the House floor. And a so-called typical emergency, all this stuff is unnecessary, in my opinion, and it would just be obstructive. In the case of a pandemic such as we're currently experiencing, or let's imagine we had a nuclear emergency at Seabrook, God forbid. But the idea that the legislature is going to get in and be sitting on the governor's shoulder and micromanaging everything that he or she does, I think is going to cause chaos and not going to be workable at all. And the fact that this bill does not take effect until the end of this current pandemic and the governor's emergency orders means that we have time to examine the situation more fully. I believe we should have, instead of this bill, we should have a blue ribbon committee that would look at what the governor has done. I agree with Representative McGuire, my chairman, that the governor's creation of the gopher, in place of letting the fiscal committee delegate and oversee the expenditure of money, which is their expertise, and under the statute, I believe they have that right. So I think the governor was excessive in his actions there. So I just think that this would be a much better outcome here if we had a blue ribbon committee that could deliberate in time, call witnesses and so forth, and get at whether the governor's emergency powers are excessive, because unlike what Representative Roy said, it wasn't all of our constituents that were complaining by any means. I had very few complaints from my constituents, and I think that there was a lot of disinformation, not misinformation, but disinformation that was promulgated from the federal government that caused a lot of concerns. And many of the claims made by the people who were complaining were simply not meritorious. So in any case, I believe that we would be much better served in the long run if this bill were not to be enacted, but rather were to be shelved in favor of a thorough, deliberative look. Please read my blurb, which is my written testimony to all of you, to see this somewhat more elegantly and articulately expressed that I think I'm doing it this morning. Thank you.
Peter, you sent the blurb to all the members?
I did. I sent it in care of, yes.
Thank you. Questions from the committee? Seeing none, thank you, Representative Schmidt.
Next, I have Representative Cushman. Representative, you should be able to unmute yourself.
Hi, good morning. Can you hear me?
Yes.
Okay. Thank you, Mr. Chairman and members of the committee. My name is Representative Leah Wilson. I'm representative for Ware and Deering, and I serve on the House Health, Human Services, and Elderly Affairs Committee, speaking today in favor of this bill as a co-sponsor. The doctrine of the separation of powers, as implemented in drafting the Constitution, was based on several generally held principles: the separation of government into three branches: legislative, executive, and judicial. The conception that each branch performs unique and identifiable functions that are appropriate to each, and the limitation of the personnel of each branch to that branch, so that no one person or group should be able to serve in more than one branch simultaneously. The response by the governor to the COVID-19 pandemic has highlighted the need to change the law to ensure that government power remains decentralized during a state of emergency. This bill allows the governor a reasonable amount of time for swift unilateral decision-making, but then shifts that decision-making back to one involving the checks and balances of legislative oversight. In the last year, the executive branch has held tightly to its position of absolute power. We know from history that power corrupts, and absolute power corrupts absolutely. It is human nature to not want to relinquish control once it is attained. Unprecedented action was taken during the current state of emergency, in which the executive created rules for the people under New Hampshire and imposed fines and charges for violating them under the color of law. A parajudicial system within the executive branch was created in violation of the Constitution. The executive branch acted as lawmaker, enforcer, and judge. Civil liberties guaranteed to us by our Constitution were suspended. The citizens of New Hampshire have one of the most representative legislatures in the Western world, with 424 members of varying backgrounds and expertise who are a cross-section of the people of New Hampshire. The legislature can be called to act swiftly if needed, but making hasty decisions is often not the best way to govern. This bill just ensures that one person cannot have absolute rule of the state in perpetuity. It aligns statute with the Constitution and intentions of the founders of our government when it was created. It protects New Hampshire from coming under complete totalitarianism under a future governor who may not show any restraint or reasonableness. I thank you for allowing me to speak on this bill.
Questions from the committee? Senator Prentice.
Actually, I have a question for Representative either Roy or McGuire. I can hold for this. I can
Okay,
hold.
any questions for Representative Cushman? Thank you, Representative Cushman.
Thank you.
Is Representative Roy still available?
Representative Roy is here. Representative, you should be able to unmute yourself.
Go ahead, Senator Prentice.
Thank you very much, Representative Roy. Thank you for taking my question, and I know I'm belaboring this point, but so if this goes, so a state of emergency, the 30-day period, getting the bodies together, majority vote, if they and the language is concurrent, so they both have to have, the House and the Senate have to agree, correct?
Yes, Senator, that's right.
So what happens if one body doesn't agree? Does this, I see that there's this continuing extension of the 14 days, but how do we get to the end?
You mean as far as ending the state of emergency?
Well, if the legislature can't resolve the issue.
Well, if the legislature, for example, let's say we're 4 months into a state of emergency, I think it's better if we at least try and play with a hypothetical.
Yes, please.
And so we're 4 months into the emergency. The governor proposes an emergency order as part of the state of emergency that we've allowed to progress. We would get together and let's say the House passes it, but the Senate can't agree with it. Well, the emergency order doesn't pass. It's null and void. So it would then be incumbent upon the governor to better educate or try to convince us why that's the best thing for the citizens of the state. And I think it's important. I know it can be scary to say that, we're going to stop the governor from doing something because we can't agree. But once, you're 3 and 4 months into it, these executive orders have the effect of law. So it's, in my mind, it's the same thing if the House and Senate can't agree on a proposed bill that we've written. Either we all agree it's good for the state or we don't agree it's good for the state. Does that answer the question?
In large part, Senator Reagan, am I okay?
Sure, it's all up.
In large part, it does. And I appreciate, I think the hypothetical is great. And there are times certainly we don't agree. And then there's a process we go through to try to, get us to agreement, like in a committee, a conference. But this is different, dealing with, again, these powers. So if we can't agree, then it's done. And the governor could either reissue or again, try to persuade the legislature. I think that's to take this back up.
Yes, there'd be nothing prohibiting him from reissuing the order and trying to lobby us as to why it's in the best interest of the state to allow the order to go forward. And like I said, that's a scary proposition, which is why he's got that 30 days of unfettered quick action. And after that, we should be able to. I mean, if it's that good an idea, it shouldn't be so hard to sell.
Okay. Thank you very much again for the clarification. Just working this out. Thank you, Senator Reagan. I'm done.
Okay. Any other questions? Do we have any other people to speak?
We do. We have Representative Blasic. Representative, you should be able to unmute yourself.
Hello, can you hear me?
Yes.
All right, thank you, Mr. Chairman, members of the committee. I'm Representative Melissa Blasic. I represent Hillsborough 21. This past year has taught us a lot of lessons concerning state of emergency laws here in New Hampshire and around the country. Overall, I do approve of HB 417, but I think that there are a few elements I would like the committee to consider. Number one, the bill does not compel the legislature to meet. I don't agree with an automatic 14-day renewal. People need to know that the democratic process is still functioning even during a state of emergency, and that includes a vote from their elected leaders. I am partial to adding the language as an exception if the legislature truly cannot meet. The quote is, quote, unless the clerk of either chamber of the legislature or the assistant clerk pursuant to RSA 14.4 has certified within the past 7 days that to the best of their knowledge, at least half of the membership of the chamber is incapacitated or missing, in which case the governor may renew a declaration of a state of emergency. Number two, I do like that HB 417 requires the legislature to approve any orders made by the governor to extend into the next state of emergency increment. This avoids the problem wherein a governor can make a single order that is objectionable, but there is no recourse other than to terminate the entire state of emergency, which may be impractical, and that is the situation that we are in currently. Number three, I also agree that any federal money should be approved. This is already standard practice in many states. Number four, in Wisconsin, for example, the legislature did lawfully vote to terminate the state of emergency, but the governor went ahead and declared a new state of emergency. While our law does already specify that the governor may only declare a new state of emergency for different circumstances, I would like this committee to consider strengthening this language. We cannot allow a future governor to abuse this check of authority. Number five, I would also like the committee to consider a nominal state of emergency. At some point, we could very well have a situation where we do need federal aid, where the state is required to be in a state of emergency to receive this aid, but we do not need the governor to have emergency order authority. Emergency order authority, frankly, is absolute power and should only be granted to the governor in the direst of circumstances. And lastly, I would like the committee to consider adding language that requires the governor to create benchmarks during his initial state of emergency declaration for what will constitute the end of an emergency. Such a bill was recently passed in Florida. So those are just some thoughts, but overall, I do approve of this bill. And I think that any changes that strengthen some checks and balances during a state of emergency is good with me. Thank you for your time.
Representative, what is your committee?
I am on Public Works.
Okay, and did you give the same testimony to House eDNA?
Well, in ED&A, they received many, many, many state of emergency bills that they sort of combined into this one. So I testified on some of the bills, but there were far more ideas being thrown around at the time even. So things have changed.
Questions from the committee? Thank you, Representative.
Thank you.
Next, we have Representative Allgro. Representative, you should be able to unmute yourself.
Yes, good morning again, and thank you. I wasn't planning to testify in this, but I stayed for the conversation, and I would like to add a couple of brief points that haven't been brought up. First, as a committee member, as a House eDNA committee member, I would like to say this. Having been a firsthand witness, as Representative Blasic said, this bill started from about 3 or 4 bills, and the committee worked hard with Representative Roy's and McGuire's and Lekis's leadership to pare this down and craft a solid single bill that's before you today. And one of the important things about it, that's a real strength of the bill, was that it was specifically crafted to take out politics and personalities. And that's why it does not address this specific emergency with this specific governor. I thought that was a tremendous strength of the bill, and I just wanted to add that. Sitting in on those meetings, being part of those meetings, we have about 4 emergency and firefighter members of the committee, and they brought up a very interesting point that wasn't in my mind before this. I'd like to put it to yours. Once an emergency has proceeded this long, it's not, to those people who are dealing with many of these aspects, it's emergency management at this point. It's not a fast moving issue any longer. And so now I'd like to just cross over and speak to you as a citizen who went through Hurricane Katrina and was a firsthand member of recovery efforts during that emergency. And I want to add that Katrina was both prolonged and very fast moving. And I just want to address the point of whether or not the legislature can get together. Again, at this point in the game, we're in an emergency management situation. But even at the very beginning, when things are fast moving and overwhelming, folks, as a citizen, I got to tell you, this isn't, if it's an emergency, the legislature is essential. They must and will get together. It's an emergency. And that's just as a private citizen, not as a member of the House eDNA. I thank you, and I'll try to answer any questions that you might have.
Questions? Thank you, Representative.
Thank you.
Anyone else?
I have Andrew Manus. Andrew, you should be able to unmute yourself.
Thank you, and thank you to the members of the committee. Hello, senators. Hello. I emailed this testimony to Cameron, so he should have it in writing. I'm supporting HB 417. Importantly, I want to point out that the language in the budget, which Representative Blasic went over with you, she actually read it out in sections 76 and 77 of HB 2 as passed by the House. I prefer that language to sections 1, 2, and 3 of HB 417. So I'm asking that you amend the language in this bill to coincide with the language in HB 2 instead of sections 1, 2, and most of 3 in HB 417. However, I very strongly agree with the language in section 3, subparagraph 5 of HB 417, as well as section 4 of HB 417. Both of those sections, I believe Representative McGuire went over, review by the legislature, as well as the oversight of expenditures. Both of those sections are critical and ought to become law. So I think there's a good structure to work with here. I believe in general, the language in HB2 is more precise and therefore less likely to be misinterpreted by a governor who might be able to, who might want to repeat the autocratic form of government we've had since March of 2020. And so I think it's important to state that, yes, this bill in particular addresses a future state of emergency. Well, I support the end of the current state of emergency, which should have been over more than a year ago. An emergency is a short period of time, such as 2 weeks, not 14 plus months. The idea that federal dollars are on the line is incorrect. FEMA funds are still available to 2 states right now that are not in states of emergency. And I think that even under current law, RSA 445, I never would have imagined abuse of power of this magnitude. The law needs to be clarified. The governor has, let me just get right to the point here. Part 1, Article 29 of the state constitution says that only the legislature can suspend laws. Part 2, Article 5 makes it clear that these same laws may not be repugnant to the Constitution. So arguably, as written, RSA 445 should align with these principles. And I think in Section 3E of RSA 445, you see it should be clear that the governor's authority to perform and exercise such other functions, powers, and duties as are necessary to promote and secure the safety and protection of the civilian population, that doesn't give him the authority to suspend law, make new law, or suspend the Constitution, because the Constitution doesn't allow for that. Even though RSA 445 says what it does, it's limited by the Constitution. But during this protracted nightmare, the governor has done all 3 things. In fact, when it comes to the institution of emergency orders written under the supposed authority of this section, the chief executive and his departments have written new policy, enforced the same policy, and created an adjudication process for that policy, effectively giving the executive branch legislative, executive, and judicial functions, which directly violates Part 1, Article 37 of the Constitution, that says the legislative, executive, judicial ought to be kept as separate from and independent of each other as the nature of a free government will admit. In other words, a state of emergency does not erase or minimize the legislative or judicial branches, and yet in practice, these 2 other branches have largely been missing in action during this state of emergency. That's something that really needs to change. The Constitution specifically calls for the legislature to manage emergency situations. And I think that that's because there are 424 people plus 1, with the governor being one of 425, that represent the whole people and the different thoughts and ideas that the whole people have. And those kinds of checks need to come together. There's no emergency where people are, the whole population is at risk of dying on day, 2, unless we're talking about a nuclear strike. And in which case, yeah, sure, the governor should have a 30-day period, 21-day period, whatever it is, to manage a real emergency. But when you have a situation where it's a virus that, granted, is really nasty, but can be managed by behavior as well as different prophylactics, I think that the legislature ought to be controlling the situation. And that's what the Constitution says. The fact that people have handed over this authority to one man is terrifying to me. That's way more terrifying to me than any virus. I can tell you that right now. As some other people mentioned, power corrupts, absolute power corrupts absolutely. And I just feel like the legislature is the body that ought to be managing this. So, I've kind of spoken from the heart more than from my testimony. I go into more detail in the written testimony.
Okay, we have a question from Senator Prentice.
Thank you.
Thank you very much. And Senator Reagan, thank you. Representative, is it Manous?
Yeah, it's former Representative Manous, yes.
For former Representative Manous. Thank you for taking my question. So you've said a few times in here, I think it should be the legislature that manages an emergency. So could you give me an example of how, and look, I'm part of the legislature, but I just want to hear from you. What's an example? Because Representative Roy did a hypothetical for me, which was helpful. And so in thinking about what is it that you envision that the legislature would actually be taking up and doing to manage the emergency?
Yeah, sure. I mean, there have been several things within this particular emergency that the legislature has already managed. For instance, violating a lawful emergency order is a misdemeanor, punishable by, I believe I don't remember exactly, but I believe it's a $500 fine. The fact of the matter is the governor has created this parallel adjudication system that has a higher penalty than what the law allows for. And there's no court to defend yourself from, perhaps this emergency order. And I can cite several of them that I believe are unconstitutional. But, this person has the right to go to court and to bring, people into that court proceeding to defend themselves and their position. And they also have the right to face their accusers who are accusing them of violating this emergency order. But under the governor's system, you have, hearsay evidence, and you have witnesses that don't have to come before the hearing to testify about the violation. So it's just a complete bastardization of justice to,
Okay, so may I, Senator Reagan?
Yes.
So, thank you very much. And when I think about managing an emergency, and we've talked, and Representative Roy did a really nice job, kind of sort of like laying out, the initial part of this. But when I think about managing an emergency, like an unprecedented pandemic that we've never been through before, I'm thinking about things like, what are the different, when the governor and Homeland Security and emergency management and local emergency managers are working together. I mean, that is managing an emergency. Where does the legislature come into that? And that might not be a question for today, but those are the concern. I think this is an able body to do great work.
Senator, your
you talk about an emergency. That's where I'm having trouble envisioning where that comes together outside of really the nice job that Representative Roy did. So maybe that's more of a statement than a question. I think I'm going to stop there, and I appreciate you taking my question, but that's
Senator,
where I want to zone in on going
respond.
into court cases and, about, who may have, a misdemeanor because of an executive order stuff. That's not managing an emergency in my mind, but that's me. Thank you, Senator Reagan.
Senator, thank you for the clarification point.
Okay, Andrew,
I have a quick.
Did you present this testimony to the House AD&A?
It was a slightly different testimony, and I did, yes.
Okay.
But to answer the question, there are laws in place that allow emergencies to be managed by the executive branch. If those laws are not adequate to address the emergency, then the legislature has not just the right, but the duty to get together and to change those laws so that the emergency can be managed differently. So that's directly answering your question, Senator Prentice.
Okay, thank you. Is there anyone else to give testimony?
I have Representative Schmidt to speak a second time. Do you want me to let him in?
Yes, but I'm going to turn the meeting over to Senator Ricciardi, as I have another commitment. So Denise, when you conclude the testimony, you can adjourn the meeting.
Thank you, Senator Reagan.
Okay.
May I proceed, Senator?
Yes, please proceed.
I don't want to testify again, but I do want to point out something with regard to a statement I believe that Representative Blasic made with regard to a so-called nominal emergency. That issue was raised in the committee in the House ED&A, and that was one of the concepts that we wrestled with. And in point of fact, the testimony from the executive branch was, I believe it was from the clerk's office, as a matter of fact, that a nominal emergency would not qualify for federal assistance. Thank you.
Thank you. Are there any questions? Senator Prentice?
Thank you, Senator Risciardi. And not a question for Representative Schmidt, but in general, do we have anybody from the governor's office that's going to weigh into this conversation? I don't see anyone on the list. And I think it would, Senator Risciardi, be appropriate for maybe our next meeting to have somebody from the governor's office, weigh in and provide some feedback if they, if they'd like. I'd be interested in hearing from them.
Okay.
And I can follow up on that. I'll check with sorry, I'm gonna.
Oh, no, go ahead. Go ahead,
Okay.
Senator.
Thank you. So if it's okay with you, why don't I follow up with Senator Carson or Senator Reagan and proceed, Senator Carson's the chair of the committee, just procedurally how it would be, I should go about that. Do you think that's okay?
Yes.
Will do. Thank you.
Are there any other questions? Seeing none, do I have a motion to adjourn? Okay, Senator Kavanaugh, seconded by Senator Prentice. I'll take roll. Senator Kavanaugh,
Yes.
Senator Prentice,
Yes.
and I'm a yes.
Thank you.